So you're all very welcome to this small practice information session or practice information session on bullying, harassment and sexual harassment. And I'm joined today by Catherine Hayes, Senior Associate at Lewis Silkin. You're very welcome, Catherine. Thanks for joining us.
Thank you for having me.
So I know this subject matter has come out of the Dignity Matters report that the Law Society issued in October of last year. I think the Law Society wants to draw more attention to what people need to do in these types of situations. So this is part of a series of three bullying, harassment, and sexual harassment series of talks that we're going to be giving. So, Catherine, you're first up, and you're going to be discussing the law and what an employer needs to know. So if you want to commence your presentation, you're very welcome. If anybody would like to take a question or give us a question, we'll take it on the chat. And over to you, Catherine. Thank you very much for joining us.
Yeah, not at all. Thank you for having me. Yeah, so I might just say just a little bit about myself first. So I'm a senior associate in Lewis Silkin, Ireland. So we're a team of 7 specialist employment lawyers here in Dublin, and we work mainly with employers of all sizes, large and small, and we also advise employees. And we're part of Lewis Silkin LLP, which is a UK headquartered company, or law firm rather, which has offices in London, Oxford, Cardiff, opened an office in Belfast earlier this year. We also have an office in Hong Kong, and we are part of Jus Laboris, which is a global alliance of law firms. So we work with law firms in other countries on employment law. So thank you for coming to this talk, and I hope that you find it helpful. So what we are going to look at today is bullying, harassment, and 3 areas. So we're going to look at the employer's duty of care. We're going to look at vicarious liability, and we're also going to look at what the law requires in terms of reasonably practicable steps. So just to start at the start, bullying, harassment, and sexual harassment, I mean, these are terms that are used quite a lot, but what do they actually mean? In particular, what is their legal meaning? So I've just set up the 3 definitions here, and I'll just go through them briefly. So workplace bullying, so that is repeated inappropriate behavior, which can be direct or indirect. It can be verbal, physical, or otherwise. It's conducted by one or more persons against another or others at the place of work or in the course of employment, which could be reasonably regarded as undermining an individual's right to dignity at work. So one of the main things to point out about this definition is it's about repeated inappropriate behavior when we're talking about bullying. And then it's also that takes place at the place of work or in the course of employment. Now, if you move on to harassment and sexual harassment, they're very similar to bullying, but they are discrimination. So harassment is any form of unwanted conduct relating to any of the discriminatory grounds, being conduct which has the purpose or effect of violating a person's dignity and creating an intimidating, hostile, degrading, humiliating, or otherwise or offensive environment for the person. So the discriminatory grounds are the 9 grounds that are set out in the Employment Equality Acts, and they are gender, civil status, family status, sexual orientation, religion, and religion includes belief and lack of belief, age, disability. And now the definition of disability is quite wide. So there could be something that you might not consider to be a disability, maybe something like anxiety or stress, or even a phobia, but that would amount to a disability under the definition of the Employment Equality Acts. And then also race and membership of the traveller community. So harassment, similar to bullying, except it is related to one of those 9 discriminatory grounds. And then sexual harassment is any form of unwanted verbal, non-verbal, or physical conduct of a sexual nature being conduct which has the purpose of or effect of violating a person's dignity and creating an intimidating, hostile, degrading, humiliating, or offensive environment for that person. So the main differences are workplace bullying, it has to be repeated. Harassment or sexual harassment could be a one-off. And I suppose just to add as well, the unwanted conduct, it could be acts, requests, spoken words, gestures, display, pictures, or other material. So it's quite wide in terms of what could constitute actions that amount to bullying, harassment, or sexual harassment. And just to add as well, where the definition of workplace bullying talks about the place of work and the course of employment, harassment and sexual harassment, it's not within that particular definition, but the Employment Equality Acts also make it clear that it applies to behaviours where the person is employed, their place of work, or otherwise in the course of their employment.
Maybe it's worth saying at this point also, Catherine, is that it's not necessarily in a physical environment. It could also be online, could it? Or
absolutely, yeah, that would be. I mean, it is in the course of your employment. So as we're all working remotely, if not full time, as we were at least some of our time, lots of people are working remotely now. That these rules also apply, and obligations also apply, much like health and safety. Still applies even if the person isn't physically in the office. So just moving on to the duty of care. So just to be clear that employers do have a responsibility to provide a safe place of work, and that's under the Safety, Health and Welfare at Work Act. And a safe place of work does include a workplace free from bullying, harassment, or sexual harassment. And then in the context of the Employment Equality Acts, there's also an obligation there that the employer has a duty to protect employees from harassment and sexual harassment. So as you might expect from the last two slides, employers can be held vicariously liable for bullying, harassment, or sexual harassment which an employee suffers at their workplace or in the course of employment. So similarly, again, this is set out in the Employment Equality Acts for harassment and sexual harassment, and then for bullying, it's set out in case law, and it normally arises in the context of a personal injuries claim. But the Safety, Health and Welfare Work Act does have an impact on because of the statutory duty to provide a safe place of work. So just to add, so it applies to employees, but there is also, it also impacts that employers can be liable for acts of, or they certainly have a duty to protect employees from acts from clients, customers, or business contexts, if the circumstances of the harassment are such that the employer ought reasonably to have taken steps to prevent it. So that's all the bad news in terms of employers' obligations, and as they are quite onerous. But the good news is that it is a defence if the employer can show it took reasonably practicable steps to prevent the conduct. And we're going to look now as to what that actually means. So really, if I'm going to summarise what this slide is, and as Justin alluded to, if you joined us at the very start, the fundamental thing employers need to have is a good policy. And this policy needs to set out that, set out what bullying, harassment, and sexual harassment is, and makes it clear that it's not tolerated. So you're talking about having a comprehensive, accessible, effective policy in place, which focuses on prevention, best practice, and remedial action. So once you have this policy, you need to make sure it has a clear complaints process so that employees they know how to raise their complaints. So they know what's not acceptable, and they know what they can do if they are believe that they're experiencing bullying, harassment, or sexual harassment. So you need to provide training to employees on this policy. And then you need to ensure that it's actually effective in the sense that it's being used, and it becomes part of your workplace culture that bad behaviors are not tolerated and complaints are dealt with fairly. So that's really what's expected in terms of reasonable, practicable steps. So on that, I suppose there are resources to help employers identify what this policy should be, but also set out the expectations on employers as to what they need to do. And they're in 2 codes of practice. So it is a little unhelpful that there are 2 codes of practice, but I suppose it does reflect that they are different types of actions, bullying and harassment and sexual harassment being forms of discrimination. So as I said, there's 2 codes there: the code of practice on prevention and resolution of bullying at work, and the code of practice on sexual harassment and harassment at work. So the code of practice on bullying, it is quite detailed. I have it in front of me now. It's 44 pages in total, and it does set out quite a lot of obligations on employers. Now, I mean, I'm not saying that it also has the legislation, and it has a lot of information in there, but it is quite detailed. But in broad summary, what it talks about in terms of how to respond to a bullying complaint, it talks about intervening early where possible. It also talks about looking at mediation. So we're trying to resolve the issue. How can we get everyone? How can we resolve it? Is mediation something that might work? And then when we're talking about a complaints process, it is a relatively detailed process for employers as set out in the code. So it talks about an informal and formal process, and you might be familiar with those from maybe grievances or disciplinary processes, where you might similarly have an informal process and a formal process. But within the code of practice, there's kind of 2 stages to the informal complaints process in the code. So there's initial phase in which the employee, if they can, will raise the concerns directly with the person that they're raising concerns about, if that's appropriate. And then if that's not appropriate or didn't work, there's also a second kind of informal stage in which a nominated person looks into their concerns. If that doesn't resolve things, or if it is not really appropriate, it also has a formal process. So this is where a complaint is put in writing. There's an investigation by designated manager or independent third party. There's a right of appeal. There's a conclusion of the formal process and a follow-up. So it is quite onerous. There is quite a lot in there. And I would recommend reading the code to get an idea of how this all works, because this is quite a high-level summary and it does go into quite some detail.
So where would I find the code?
Yeah, so actually, I think you have a link that you might share that actually goes to the Law Society website. But it's published by the Health and Safety Authority. So if you go to www.hsa.ie, and then there is one of the tabs on the homepage is topics. And if you click onto topics and then click down to bullying, it has a link to the code there, because it is published by the HSE and the WRC together. And then the HSA's website, well, also the link that you have, that is for the Law Society, that has lots of helpful resources, including a link to the HSA website. But the HSA website in particular has lots of guidance. It has Q&As, and it's quite helpful in terms of trying to figure out what you need to do. So just going back to the code, as well as the complaints process, it also has some guidance on preventing bullying. So it talks about how employers should focus at promoting and reinforcing a positive workplace culture, and provide appropriate training for those managing complaints and managers. And it also has, I mean, it's not entirely prescriptive in the sense that it doesn't say this is absolutely everything you need to do, though it does. Everything that's in the code is best practice, and employers to an extent would be expected to follow it. But it also acknowledges that smaller organizations will have different resources and maybe taking different approach to a larger organization. But for example, in the context of a larger organization, you might have appoint a contact person that employees can contact if they have concerns about bullying. So this is someone separate to the process. It's kind of like an information person, really, that can help explain how the policy works and what someone can do if they have concerns. And then the code also talks about, as I mentioned earlier, mediation, and that talks about internal and external mediation. And maybe if you have a larger organization, you could look at training mediators within the team. So we also have a code of practice on sexual harassment and harassment at work. And this was just new codes, an update to the code was just published earlier this year. And the bullying, just to say, the bullying code does acknowledge that you could have one policy which deals with all kinds of complaints. And generally that would what we would recommend, having a policy that covers all three types of concerns. And we would, so the codes of, even though there's two codes of practice, they do follow a similar approach, particularly in the complaints process, with an informal process, possibility of mediation, and a formal process if none of those earlier stages have been appropriate or successful. And again, in this code, there is a focus on prevention. So focus on creating and maintaining a working environment in which the dignity of employees is respected. And similarly to the bullying code, it talks about maybe introducing a senior level champion, which might be something larger organizations consider. And the code also talks again about providing training and recommends monitoring the effectiveness of the policy. So that code as well, it's 32 pages long, so it's a little shorter, but it really sets out the law really clearly. And that code of practice is published by the Irish Human Rights and Equality Commission. And as I said, it sets out the law really clearly. It's really quite helpful, and particularly if you're a lawyer, because it is a little, and setting out the law is a little legalistic, but something that, you know, lawyers will be familiar with looking at. So I think it'd be an easy document for you to read. Yeah, both those are the two codes really that you need to be looking at when you are deciding what you're putting in your policy. So I think that is all I was going to say. It's really, I suppose the focus is really, you need to have the policy. You need to provide training on it, and you need to follow the policy. And that's really the core, I suppose, the core recommendation I would have in terms of dealing with these issues.
Okay, thank you very much, Catherine. So we'll open the floor now to questions, and I suppose so if you want to send us in a question, we'll take it over the chat, but I might just open the question. But just when you talk about the policy and procedures, if I have a staff handbook at the moment, does that need to be updated to make explicit, how would you say, notice to this material? Or
to the new codes, or
yes.
Yeah, so it depends. Really, I would recommend having a look at your policy and seeing, is it still fit for purpose based on the two new codes. whether there's anything that needs to be addressed, whether it's just making it clear, like you mentioned earlier, that when we're talking about behaviors that are not tolerated, that's not just behaviors in the physical workplace, it's while everyone's working remotely. It could be things like that, depending on what you have in your particular policy. But I would recommend taking a lot of it, see if it's fit for purpose, see if it's working, and have a look at the two codes and see, is there anything that you might need to add to it.
And if a complaint is made, be it verbal or written, is it the existing disciplinary code that would manage this process, or is it a separate process?
So when you're talking about a complaint of harassment or sexual harassment or bullying, you don't jump to the disciplinary first. What you should do is deal with it under most employers call it a dignity at work policy. So it needs to be, it's not like other allegations of misconduct. It needs to be treated differently. So you need to go through the steps that I mentioned in terms of whether you can deal with it informally, if not, deal with it formally, which means it's properly investigated. And then it's only if at the outcome of the investigation that that you may be moving to the disciplinary process.
Okay, so the handbook or the policy needs to make explicit reference to sexual discrimination, bullying, or harassment.
Yes, yeah, you need to have a policy which sets out, this is what bullying, harassment is. This is what these three things are. This is what you need to do if you have a complaint.
Yeah, and I guess the point I'm trying to make is, if I don't have any policy at all, I need to get a policy, and I need to update it accordingly. But if I have an existing policy, I should be checking it to make sure that these new issues have been adopted within it.
Exactly, and just to, as I clarify, that it's separate to any disciplinary policy.
Yes. Okay. And if the intention, just talking about the definitions of harassment, bullying, and sexual, like, is this an exhaustive list that I need to capture every single scenario in my policy, or is there a catch-all umbrella? Or
no, so I'll just go back to the definitions, because they're a bit ambiguous in some ways, aren't they? Really, what do any of these things particularly mean? And in the codes, they do give examples of what they are, and they're not exhaustive examples. The definition is quite broad, so it can capture it captures a lot of behaviors, as long as they are reasonably regarded as undermining dignity at work, and they're inappropriate, or they have the purpose or effect, if they're related to discriminatory grounds or sexual harassment. But within the code on bullying, for example, some of the examples of behaviors which make for bullying pattern will likely include not just one, but a range of the following behaviors. So they talk about exclusion with negative consequences, verbal abuse or insults, being treated less favorably than colleagues in similar roles, belittling someone's opinion, excluding someone, things like that. So within the policy, most policies would have some examples from the codes of what bullying, harassment, sexual harassment might look like, but they're not exhaustive. But it's just to help employees and employers identify what they are in practice, because the definition is, it may not be easy to identify whether something falls within it just by looking at the definition.
So that brings me kind of nicely on to the next question with regard to the responsibilities of the employer. If, as you just said previously, that it's quite a large list and may not be readily apparent that this is happening, if I'm unaware as the employer that this type of activity is occurring within the workplace or outside the workplace, but in an employment environment, do I have responsibilities around that? Am I liable?
Yeah, you still do, because you have a duty to have to provide a safe place of work. You have a duty to employees that they're not going to be exposed to bullying, harassment, sexual harassment. But then how you do that is by putting in these reasonable practicable steps, by having this policy in place, so that and giving training on it, and and taking steps to ensure that employees know that this policy exists and the processes. And so you can't just say, oh, I didn't know. You also need to have a system in place whereby employees know how they raise it to you, employees know what's acceptable and what's not acceptable, and what the complaint process is.
And that needs to probably be documented at your end so that you could prove that in the event of some
Absolutely, yeah.
And then you mentioned training. What type of training are you suggesting that might happen there?
So it obviously varies in organizations. So obviously there could it'll depend on particular organization as to what kind of training they provide, but particularly in inductions, a lot of employers would be providing training on what the various different policies are. So it's that type of thing. It really kind of, I suppose, depends on your particular organization and I suppose what the concerns are. Within a larger organization, obviously there's more resources to provide training on I suppose maybe more specific issues that might have arisen within a smaller organization. There's, I suppose,
so it's not a prescriptive training that they need to engage in. You just need to, as the employer, demonstrate that you've made some attempt to educate the staff around these issues.
Yes, yeah. And I'm not sure I have a feeling the HSA might have some help on that. I haven't checked in a while, so I hope I'm not wrong on that. But they certainly they may have some resources on that.
Okay. And is a lack of respect towards another staff member or manager to you, is that harassment?
If it's to do with any of the discriminatory grounds, it could be. It really depends on, I mean, a lack of respect. It depends how that's, what does that mean? So if I would, if a client came to me and said that, I would kind of tease out, well, what does this lack of respect mean? How is it, what does it break down into? Is it someone being rude? Are they making dismissive comments? Are they ignoring instructions? Because it could be bullying, or it could be harassment, or it could be poor performance. It really depends on the context and a little more detail as to if that's someone being disrespectful, what that actually is.
And can staff make a historical complaint around these matters, and if so, how long would the time period be?
No, there's no time period. I mean, the difficulty with making a historic complaint is investigating it. And if it's a historic complaint, you would kind of expect that, it's a difficulty with investigating if it's something that's happened so long ago. It can be difficult to look into it.
So the issue there will be proving it if it's over a longer period of time, but there's nothing to restrict somebody making a claim that goes backwards, but they would need to be able to provide evidence.
Yeah.
And what if a client is behaving inappropriately?
So
what's your responsibility as an employer in that situation?
So you still have a responsibility. So it goes back to having this policy in place and setting out that, even if an employee is experiencing bullying from a client, that they bring that to your attention. And while you're obviously not going to be, it's very different to when a complaint of bullying is made against another employee. You still need to address it, and you still need to deal with it, and you still need to protect the employee from bad behaviors. So it will depend on particular context as to how you deal with it.
And can workplace bullying take place outside the workplace? For example, sending an offensive text or verbally abusing a colleague outside of the office hours?
Yeah, so that goes down to this whole course of employment aspect, and whether something is whether something happens in the course of employment. So yes, it could be outside of normal working hours.
So if I meet somebody in a social situation at the weekend, totally unrelated to work, but I meet them in a pub or something like that, and something happens, is the employer liable in that situation, or?
It will depend on
what happens.
It will depend, I'm afraid, is the horrible answer. But I think that doesn't sound like it's in the course of employment.
Yes.
But yeah, it doesn't sound like that's in the course of employment. But it all depends, and it depends on the relationships. It depends. It's a complex, and I appreciate it's a really difficult area for people to deal with. It's really challenging, and it's not easy. But it's, I suppose, just going back to the point, it's about having a policy in place that you can go to, and in these difficult situations, having a good policy is something you can go to and work from there to deal with this difficult area.
Listen, Catherine, thank you very much. We're out of time for today. I know we've made a recording of the session. We'll send it out on Friday. Thanks very much for your time and your really useful insights into this this difficult issue that we need to grapple with and get better at dealing with. So next week we have another session with regards to prevention is better than cure, and I'm joined by Moila Brady Bates, and we're going to be discussing sort of instilling positive and healthy workplace cultures, awareness of what bullying, harassment, and sexual harassment is as a bystander, and bystander intervention, and the best practice in terms of working policies. So, Catherine, once again, thanks very much for joining us. Hopefully, you'll all join us again next week. Sloanos Gurmao Guts.
Okay, thanks very much.
Thanks, Catherine. Thank you. Bye.
Bye.